I certainly do agree with the prosecutor that I think upper end is a proportionate sentence here. So there's $136 in state cost, $130 in a crime victims assessment, $350 in court costs. Mr. Warner has been registered with the Sex Offender Registration Act. He has to comply with that. And on the charge of accosting minor for immoral purposes, I'm going to commit Mr. Warner to the Michigan Department of Corrections for a term of not less than 23 months, nor more than 4 years, with credit for 288 days previously served. Do you want to state your appearances for the record, please?
Mr. Goodrich, Blaine County Prosecutor.
Dominic F. Andrew, Jr., Your Honor, on behalf of Mr. Warner, seated to my right.
All right, and we're here for sentencing that's been adjourned a couple of times. All right, so Mr. Andriaki, have you had a chance to review the pre-sentence report with your client?
Yes, Your Honor.
All right, and you do you have any additions or corrections, or just scoring challenges?
No additions or corrections. Scoring challenges, and I guess maybe it might be an addition or correction, potential issue with one of the victim impact statements. I don't know how you would classify that, but.
Okay, well, let's see. I received written victim impact statements from a minor, we'll just use initials for minors, is that
Yes.
right? Minor PW.
Yes.
And I received one from...
This is one of those sentencing hearings where the courtroom feels calm on the surface. But underneath, every single word carries serious weight. You're about to hear a judge navigate a case involving a minor, prior misconduct, sentencing guidelines, and two of the most contested issues in Michigan criminal law, psychological injury and predatory conduct. The prosecution wants the upper end of the sentence. The defense wants key scoring factors wiped off the board. And the difference between those outcomes isn't just academic. It directly affects how long this defendant will spend behind bars.
Correct. So you're not talking about those two. Are you talking about the one from the adult victim impact statement?
Yes.
Okay. What do you want to say about that one?
Just that essentially the PW's mother is not a victim for these cases. She's not a complainant in either one of them. The complainant is PW. Because PW made her own statement and did not designate her mother to be making a statement on her behalf, we would request that that statement be stricken. The adult statement be stricken.
Okay. Ms. Goodrich, your response to that?
Your Honor, technically by the statute, I would agree that because the victim wrote a statement, typically defense attorneys just allow the mother or the parent to also make a statement. But once the objection's made, then I don't really have a response to that because the victim did make a statement and stands by that.
Okay. So I will, obviously I read these when they come in, but I will disregard and strike anything in the written impact statement from the victim's mother and not consider any of those facts in the scoring of any guidelines.
Thank you, Your Honor.
Okay. So I do have the written statement from the minor victim.
Mm-hmm.
All right. And so why don't we go, we've got two charges. One, the accosting a minor for immoral purposes, which is scored at 5 to 23 months.
Mm-hmm.
And then using a computer to commit that crime, scored at 10 to 23 months. So maybe why don't we take one objection at a time? So give me one scoring challenge and we'll
Sure.
go from there.
You want me to? We've had a little bit of discussion about these at the prior ones. I don't know how much you'd like me to go over those again.
I guess I'd like a refresher then.
Sure.
So what OV or PRV are you challenging first?
Of course. Thank you, Your Honor. We're challenging OV4 and OV. Where is that other one? Forget the number of it, but it's the
OV10.
OV10, yes.
Okay. So let's do OV4 first. That's serious psychological injury to victim, and that was scored. Well, it wasn't scored in the accosting, but it was scored in the using a computer to commit a crime.
Correct, Your Honor.
Okay. And you believe that it should be scored at 0 points in both?
At this point, the judge has already made something clear. Prison time is happening. This is not a probation case. And it's not a slap on the wrist. A minimum of nearly 2 years, with a possibility of up to 4, puts this firmly in serious felony territory. But What's important here is that sentencing isn't over just because the term is announced. Michigan's sentencing structure depends heavily on offense variables, and those variables can dramatically shift the outcome. That's why both sides are about to zoom in on the pre-sentence report. This is where defense attorneys can gain or lose months or even years.
Even if it scored for the accosting, you think it maybe shouldn't score for the computer crime?
Correct, Your Honor.
Okay. All right. So why don't we take sort of level one of that is tell me why it shouldn't score why it should score for neither of them.
Okay, perfect. Thank you, Your Honor. So OV4 is a offense-specific crime or offense-specific OV, and that's according to People v. McGraw. So when we look at OV4, and I know in particular it's the victim impact statement, right? So when we look at the victim impact statement, the complainant or the victim, PW, states that she has started or continued counseling and has increased her medicine for anxiety or some sort of diagnoses based on family members blaming her for Mr. Warner being in jail. Now, because of McGraw, we have to look at what did Mr. Warner do, and did that necessarily necessitate some serious psychological harm needing treatment? According to the complainant's own, or the victim, again, I apologize, the victim's own statement, it's based on other people putting these pressures or saying these things, not that anything Mr. Warner specifically did. And for that reason, it should be scored at 0 for both of them. The additional argument would be there's no additional fact that because he used a cell phone to text the complainant, that use of a cell phone or use a computer to commit a crime.
So under McGraw,
Yes.
using a computer to commit a crime would not have resulted in serious psychological harm. So that even if it did score for the accosting, it shouldn't score for the computer. Is that your argument?
Yes, Your Honor. You've got it.
But that your broader argument is that even though the written impact statement would support that there has been serious psychological harm, there's insufficient evidence on this record that has stemmed from the sentencing offense, that it has perhaps stemmed from post-sentencing offense conduct by.
This exchange might sound procedural, but it's actually a crucial moment. Victim impact statements carry emotional weight, but courts can't just accept them freely without legal limits. Here, the defense isn't denying harm. They're challenging who is legally allowed to speak as a victim. And the prosecutor, notably, concedes the law. Once the objection is raised, the judge has no choice but to strike the mother's statement. That's not disrespect. That's due process. It's also a reminder that sentencing must be based on admissible, victim-specific evidence. Emotional narratives matter, but only when they fit within the statute.
People other than your client.
Correct, Your Honor.
Okay. Ms. Kudrich, what's the people's response to that?
Oh, Your Honor, I think that the being the victim of this offense had caused psychological harm, and being certainly a minor, difficult to explain, that but for his actions, she would not have to endure the consequences of coming forward and being honest and reporting him. This all stemmed from what he did to her that night, and I think that's just her explaining one of the things that happened as a result of that. She calls him a predator. He's come at her 3 times prior, and she says, "I've had to go to counseling weekly. I'm on a higher antidepressant," and then says, "because certain family members have blamed me." So certainly that's all encompassing of what she's had to endure as a victim, which is typical of a victim. I think that the device that he used in order to commit that accosting was the computer. So, but for him not having a computer available that night, he would not have been able to accost her and cause that psychological injury. So I think that was a vessel to create that psychological injury. So I think it should be scored 10 points for both.
Right, thank you. Well, I think what the prosecutor has articulated about the sort of the dynamics of sexual offense against a minor and what they might typically experience and how that sort of flows into when other family members don't believe that victim, and blaming them, that can compound the harm. I don't take issue with any of that factually at all, as a general matter, and even as a specific matter in this case. However, the case law on OB4 is, I guess, both broad and tight at the same time, or narrow at the same time. It's broad in that the amount of evidence needed to score for serious psychological injury is not a particularly onerous threshold to meet. But there are some limitations, that it has to be victim specific, and there has to be specific evidence that that particular victim has suffered a serious psychological injury as a result of the sentencing offense conduct by the defendant. People v. McGraw, the Michigan Supreme Court has cautioned that we cannot consider post conduct that occurs after the sentencing offense is completed. Also, the case law cautions trial courts not to score OB4 based upon sort of these reasonable victim, or what a minor would typically experience under this circumstance, as the prosecutors articulated. Again, I don't disagree with any of that as a factual matter, but as a legal matter, that would be insufficient. We did adjourn this sentencing to allow for even testing.
Now we're in the technical heart of sentencing. 2 charges, 2 guideline ranges, and multiple offense variables that could push the sentence higher or lower. These numbers aren't arbitrary. They are the backbone of Michigan's structured sentencing system. And when the judge asks for objections one at a time, that's deliberate. Each variable stands on its own legal foundation. Lose one, and the entire guideline range can collapse downward. This is where experience matters, because arguing these variables isn't about rhetoric. It's about precedent case law and tying specific facts to specific legal standards.
Testimony, if the people wanted to present that. What we have is a written impact statement, and upon reviewing that written impact statement, it only establishes that the minor victim has had to go to counseling and change medications because, and then she gives the reason for that, and it is other family members blaming her for Keegan being in jail. All right, Mr. Andriaki, as to OB10.
Yes, Your Honor.
It's scored presently at 15 points in both counts for predatory conduct.
Correct, Your Honor. And we would challenge that and believe it should be scored at 0 points. Primarily because there's nothing here to establish any kind of predatory conduct in specific to these offenses themselves. The using a computer to commit a crime. There's nothing that shows that this complainant was, again, this victim was predisposed to sending or receiving, inappropriate pictures by use of a cell phone or through Snapchat. And additionally, as far as the accosting goes, there is, on a lower level, at the 10-point level, there is a relationship between the victim and Mr. Warner. They are related. So there is that. However, there is no exploitation here in the respect that she was with another person, another juvenile, I believe, at the time, and she refused to provide any kind of incriminating photos or anything of that sort. In fact, she turned around and reported the conduct, which is why Mr. Warner is here. And as the statute and the case law discuss, the mere presence alone is insufficient. So for those reasons, we would request that OV10 also be scored, especially for the using. The accosting is a little bit, I understand, a little bit tougher for Your Honor, given that, there is the 10-point difference there. However, especially when it comes to the cell phone portion, we believe it should be scored at 0. Thank you.
Can I ask you
Of course.
one question in my mind as I look at this with
Sure.
predatory conduct, that's defined as pre-offense conduct directed at a victim for the primary purpose of victimization.
Yes.
And the classic, I guess, situation for that is what's commonly referred to as grooming behaviors before the offense itself.
Sure.
And here, I'm not sure that there's a record of that until this offense occurred. With the major question in my mind, that your client has a previous juvenile adjudication for victimizing this same minor.
Mhm.
That is pre-offense conduct to this offense.
This is a textbook OB for argument, and it's a strong one. The defense isn't saying the victim wasn't harmed. They're saying the harm described doesn't legally trace back to the sentencing offense itself. That distinction is everything. Under People v. McGraw, the court can't score psychological injury based on what happens after the offense or due to actions by third parties. The victim's own words matter here, and the defense uses them carefully. Counseling, medication, anxiety, those are serious. But if they stem from family backlash rather than the defendant's conduct, the law says OB for cannot be scored.
Does that constitute predatory conduct that kind of bootstraps into this case at all? Or does the passage of time, does there need to be some sort of continuing sequence of events?
Yeah, that's a very good question, Your Honor. And I think just shooting from the hip here a little bit on that. I'm
thinking from the hip.
Yeah. I think the like you had just mentioned, if there was some sort of, especially with grooming, you notice some sort of, they befriend, they, start doing these side jobs or whatever, and all of a sudden they're like a Boy Scout kind of thing where they establish this relationship, and then over the course of 6 months, 12 months, they start amping up the sexual misconduct, right? I think when we look at this factual record, yes, there is the prior conviction, but there's nothing to show what happened between the prior conviction and today. What's the grooming conduct that's the supposed predatory conduct that occurred to lead up to this moment, other than that prior offense? Maybe there was something there, but I think, as you had mentioned, again, we have to look at the preponderance of the evidence, of the facts, and it's either come through a victim impact statement, testimony, through an actual oral statement, or perhaps something through a prelim or even a police report. We don't see that in this factual record. So I think that's a very good question. I think factually it could establish something to that effect. In this particular case, I don't see where the facts are there. So I would agree based on that. That's another.
And so you think that OB10 is properly scored at 0, not even the 10 points, because there's no exploitation. So if the accosting is sort of the soliciting or sending of something,
Yes.
that then by your reasoning, that would never support, or on those facts would not support the exploitation of a vulnerable victim. Mm-hmm. There's plenty of times where accosting is pled down from other behavior, but if the accosting is truly the sort of soliciting, the without invitation, sharing inappropriate messages or pictures, and the solicitation of them to reciprocate, that conduct itself does not amount to manipulation for selfish purposes to constitute the exploitation. Am I understanding that right?
Yes. I think, in other words, I think there has to be an additional fact. So let's say, for example, let's get into a little bit of a hypotheticals. I think that might be helpful. I think if there's something, there's predatory conduct where a person goes out and, they case a playground, or they know that the parents aren't there, or they already have some sort of cell phone, and they choose one family member as opposed to a second family member. That, I think there's a little different factual scenario there, where there is something over and above just the mere relationship or the age itself. Let's say, for example, there's a bunch of children at the playground, and a defendant chooses one.
The prosecution's argument is emotionally compelling. that everything flows from the original offense, that the harm is inseparable from what the defendant did. This is a common and understandable position in cases involving minors. But notice how the judge listens. He doesn't dismiss the emotion. He acknowledges it. Then he separates fact from legal sufficiency. Courts are warned not to score based on what usually happens to victims, but what does victim experience because of the defendant's conduct? That distinction is uncomfortable, but essential. This moment shows judicial restraint in real time, even when the subject matter is deeply sensitive.
Out of that group of 5 kids, because there's a younger person watching them and there's nobody, the parents leave or something. I think that sort of circumstance, definitely predatory conduct. Even there's 2 siblings back to back, they choose one because one of the younger siblings has something in their background, maybe a learning disability or something that they could manipulate to their own gain. I think in those sort of circumstances, an accosting would support points even under OV10 for predatory conduct, or even the youth agedness and so forth. In this circumstance, I don't see, there's nothing to kind of give more, I guess, context as the way I would kind of look at it as to that.
What about, I have one more question for you before we hear from the prosecution. And this is back to predatory conduct, pre-offense conduct.
Mm-hmm.
Why can't I parse out the messages so that the messages as it begins in the offense narrative,
Mm-hmm.
there's this message back and forth, he's reaching out, what are you doing?
Mm-hmm.
And then he's talking about his mood. He's talking about, he's making some references to, I guess he's sort of leading up to that he's got some sexual urges.
Mm-hmm.
Before he's asking her to be engaged with any of that, he's sort of leading the conversation in that direction.
Sure.
Why wouldn't that constitute the pre-offense conduct before the act? Because that's not criminal at that point. So then once there's the criminal event in the conversation, can I count the previous leading up to that moment as pre-offense conduct directed toward victimization?
I don't believe so, because I think it's all part of the same transaction or occurrence, so to speak. I'm trying to think when we see like the Chris Hansen kind of things.
They're doing some things on it because I've scored it in those cases. I've had a couple of those sting operation cases, and they stop along the way and they get some things, or they communicate with them several different times. So it's more than one conversation.
Yes. I think in that circumstance, arguably OV10 can get scored that way. I think in this one, especially too, one of the other factors here is she says, if I'm not mistaken, that she's with somebody else at the same time that he's sending these messages to her. And there's not it's not really even a back and forth. It's just he's stating these things to her and she's pretty much not reciprocating.
Okay. All right. Thank you. I think I understand your position. Ms. Goodrich, what's your
Thank you, Your Honor.
Thank you, Your Honor. I would ask that the court consider the case 2003 case People versus Witherspoon, 257 Mishap 329. In that case, the defendant, it was an in-person assault case, but the defendant had waited till no other person was present. There was waited till the child was in the seclusion of a basement and watched the child and waited for her to be alone before the assault. So the defendant in this case is going to use a phone to commit the accosting. So what does he do? He uses the fact that he's a relative, that they have this previous relationship. She has been previously a victim of his actions. He knows her. He knows how to manipulate her. He waits till she's at a friend's house. He waits. There's no parent around. There's no other adults around. It's just only her and another juvenile.
This is one of the most revealing moments of the hearing. The judge raises the issue no one wants to avoid: prior victimization of the same minor. On its face, that sounds like textbook predatory conduct. But the law requires more than history. It requires direction, intent, and pre-offense conduct tied to this crime. The defense leans into the gap. No evidence of grooming, no sequence of escalation, no documented conduct bridging the past and present. This is where judges earn their paychecks. The question isn't whether the past is disturbing. It's whether it legally qualifies to increase punishment today. And that's not an easy call.
Friend. He then has the setting in any location. No, it's the location of the bedroom that she has at her grandmother's house. So he's in her bedroom when he's texting her and doing this accosting. He's laying in her bed to get her attention, to get her to engage in the conversation. He initially sends innocent texts. The exploitation is properly scored at 15 points.
Thank you. Any rebuttal argument to that?
Not primarily, Your Honor. Again, I think we've discussed it. I wouldn't say anything additional. Thank you, Your Honor.
All right, this is presents an interesting question. The statute, the statutory sentencing guidelines for offense variable 10 are for exploitation of a vulnerable victim. And it's been scored by the Department of Corrections at 15 points for predatory conduct being involved. Predatory conduct is defined as pre-offense conduct directed at a victim for the primary purpose of victimization. And here, the prosecutor, I guess I'm persuaded by the prosecutor's argument presented here today that there were a series of choices and decisions and actions that the defendant made leading up to the criminal exchange on the text, with his placement of where he was, the exploiting that relationship, waiting until the victim was at outside of her parents and her home, and then some of the messages leading up to the criminal parts. So I think that all of that is pre-sentencing offense conduct. It does involve a series of choices, decisions, and actions. They are directed toward this victim for the primary purpose of victimizing her with the accosting by the computer, which he did. So I think the prosecutor has laid out some pre-offense conduct that would support that score by preponderance of the evidence. So I'll leave OV 10 scored at 15 points for both counts. So I've sustained the challenged OV 4 in the computer crime. So that would lower that from total OV 30 points to 20 points. So that would then be, get to the D grid here. That would be from OB level 3 to OB level 2. And that would then be, instead of 10 to 23, it'd be 5 to 23. Is my math correct, Mr. Andracki?
I believe so, yes, Your Honor.
Ms. Goodrich?
Yes.
All right. Any other scoring challenges from the defense?
No, it was just OV 4 and 10. Thank you.
Any scoring challenges from the people?
No, Your Honor, thank you.
Okay. Mr. Andriaki, any allocution you want to make on behalf of your client?
Yes, thank you, Your Honor. I think when we consider this case and Mr. Warner as a whole, unfortunately, there's a significant amount of substance abuse history for him.
At the end of the day, the sentencing hearing is a powerful example of how criminal courts balance harm, accountability, and legal boundaries. The judge imposed a serious prison sentence while also enforcing strict limits on what could and could not be used to enhance that punishment. Objections were sustained not because harm didn't exist, but because the law demands precision. That's how the system protects its integrity, even in emotionally charged cases like this one.